Keith Becker, the General Manager of Deedee's. AB 1482, the Tenant Protection Act of 2019, is a fairly complex bundle of law. However, it can be broken out into 5 major subject matters. Today, we're going to speak about the exemption for single-family residences. Now, before we go on, I want to express that we are so very early in this process, so the thoughts, the recommendations that we may have now may be finessed over time as we actually institute the intricacies of this law. Second, I am not an attorney, so every situation is unique, every situation is different. If you have legal questions, please do ask your attorney. From the top, AB 1482 is actually a rent control law. It limits rent increases on those units that are impacted to an amount no greater than 5% plus CPI. If CPI exceeds 5%, the maximum cap on increases is no more than 10%. In addition, it limits the reasons why a tenant might be requested to vacate to a very short list of reasons. And lastly, in some of those instances, if you ask a tenant to vacate, you may be obligated to pay to them relocation costs. Talking about exemptions, AB 1482 states that this law shall not apply to the following, and the following includes residential real property that is separately alienable from any other unit. Separately alienable effectively means, can you sell one residential unit without also being required to sell another with it? This is effectively single-family residences and condominiums. So if you have a duplex, you can't sell one half of the duplex. However, a condominium, although it's in a community of maybe hundreds of properties, you own one specific space. That's why a condominium is alienable, is separately alienable, and a duplex is not. Now, this clause in AB 1482 states that it shall not apply to the following. It says residential real property that is alienable from any other as long as both of the following apply. First, the property cannot be owned by a REIT, real estate investment trust, a corporation, or a limited liability company in which one of the partners is a corporation. This is an attempt, a purpose of excluding those companies that came in and bought single-family residences in the immediate aftermath of the Great Recession. It excludes them from any protections that might be offered by this exemption. I will say that if you do not understand what an REIT is, what a LLC is, it doesn't apply to you. So most single-family residences owned by small investors will not be impacted by this provision. However, you also, coming back for a moment, you notice it said, provided that both of the following apply. First is the ownership. The second is, you must provide to your tenant written notice that the residential real estate is exempt using the following statement. Specifically, this statement in these words quoted verbatim. Both must apply. It's conceivable to lose your exemption if you think that, oh, I've got a single-family residence, therefore this does not apply to me. If you forget to put this into written documentation to your tenant, you could fall under rent control. To protect the exemption, the statement must be included in any new tenancies instituted or renewed after July 1st of the year 2020. If for tenancies that existed prior to July 1st of 2020, you need to have this into their documentation no later than August 1st of the same year. My recommendation would be there's no reason to delay, do it now. The notification, not only do you have to use the specific verbiage, but AB 1482 states you must put it in 12-point font. It must be large enough that it is not buried in the fine print. The provisions of AB 1482, including the exemptions, including caps, including how much we're allowed to charge, are specific to only 1482. So theoretically, if at some point in the future Costa-Hawkins is overturned, it could actually undermine even the exemptions that you might find within AB 1482. Accordingly, it is very important that you remain informed, and it's very important that when the opportunity comes, vote. Please. It is complicated. This is only going to get more complicated as we go along. If you have questions, contact a real estate professional, contact a property management professional. And again, if you have legal questions, call your attorney. I'm Keith Becker from Dede's.